Across the country, states and municipalities have been enacting ban-the-box laws. These laws prohibit employers from asking prospective employees about criminal records on employment applications and, in some cases, dictate when in the hiring process an employer can conduct a criminal record check, offering a fresh start for many applicants. Ban-the-box laws are certainly well-intentioned. By removing questions about criminal history from employment applications, people with criminal records face fewer barriers to employment. By banning the box, otherwise qualified individuals are not automatically disqualified by employers simply for having a criminal history. These laws vary widely across states and cities, creating a patchwork of regulations. Employers must navigate these differences to ensure compliance and fairness in their hiring processes. Here's the rub. Ban-the-box laws could make employers more open to negligent hiring or retention lawsuits if an employer decides to take a chance on an individual with a criminal history. Ban-the-box laws do not absolve employers from the liability that comes from hiring or retaining a bad employee. On the flip side, ban-the-box laws could make employers more likely to face discrimination claims if they do not hire an individual with a criminal history. As these laws generally push criminal history checks to later in the hiring process, job applicants could be more likely to believe that they are qualified candidates. If they are eventually disqualified later in the process after a criminal history check, the perception could be that they were discriminated against because of their criminal history. Consult with your employment attorney to ensure that you are compliant with your local ban-the-box laws. Double-check what to do if your company hires people in multiple jurisdictions, or if you operate in a jurisdiction where you are subject to both state and local ban-the-box regulations. Carefully review your hiring practices to determine what criminal history and other information are necessary and relevant for the job positions you are hiring for. Have clear, justifiable, consistent guidelines for what types of criminal offenses would disqualify a candidate and retain hiring records. Some jurisdictions, such as New York City, make it mandatory for an employer to disclose the analysis used in disqualifying a job candidate. Even if your jurisdiction doesn't require such disclosure, document everything in writing. Partner with a background screening firm capable of providing you the quality and depth of information necessary to make sound hiring decisions. Also, make sure your background screening partner is well versed in the Fair Credit Reporting Act, FCRA, and other local regulations to ensure that the firm only reports criminal record information to you in accordance with the law. Ultimately, responsibility for compliance falls to the employer. Take proactive steps today. For assistance in these matters, contact us at the email or phone number provided.